side will have 20 minutes to make their arguments. Appellant, you may reserve any amount of time that you wish for rebuttal, but you'll have to keep track of that time yourself. We have a clock at the podium for that purpose. Yeah, uh, we are recording the argument, so when you approach the podium, please identify your client and yourself so that we can keep everything straight. In a couple of days, this argument will be on YouTube. We've we've conferenced this case. We've looked at the record. We've read the brief, so we're familiar with the facts and the law. So when you come to argue, please just start out with the point that you want us to know and to discuss. Counsel, you may begin.
May it please the court, my name is Christina Reeves and I represent the appellant, the mother, Serah E. Your Honors, parents have a natural, moral, and legal right to their children. Nearly a century ago in Myers v. Nebraska, the United States Supreme Court recognized that a parent's right to their child is a fundamental right. In the Parents' Bill of Rights, the Arizona legislature codified that finding into Arizona law. ARS 1-601 states, quote, "The liberty of parents to direct the upbringing, education, health care, and mental health of their children is a fundamental right," end quote. In Santosky v. Kramer, the United States Supreme Court made clear that when the state seeks to infringe on a parent's fundamental right in the most severe, the most permanent way possible, when it seeks to end it, quote, "When the state moves to destroy weakened familial bonds, it must provide the parents with fundamentally fair procedures." In Arizona, the state destroys families without providing fundamentally fair procedures.
Counsel, I take it you're making a constitutional argument, and my first question is, was this exact argument made to the juvenile court?
We are arguing, as far as the statutes themselves, we are arguing that they are unconstitutional.
Yes,
They're facially unconstitutional under the federal constitution, they're facially unconstitutional in the Arizona constitution, and they violate the parents. None of those arguments were made in the court below.
Then how can we consider them in the first instance if you haven't given the state the opportunity to answer below?
We have two responses to that. One is that statutes that are facially unconstitutional, as the Supreme Court decided in Marbury v. Madison, statutes that are unconstitutional are void from the time of enactment.
But that doesn't answer the question of waiver or forfeiture.
Our argument is that a challenge to the facial unconstitutionality of the statute that the state relied upon to take action in the lower court is so fundamental that it can never be forfeited.
But counsel, does that turn on any facts? I mean, what's the test for facial unconstitutionality?
The test for facially unconstitutionality is if the statute is unconstitutional on its face, as opposed to it was simply applied.
Every instance, right? It has no possible constitutional application. Isn't that the law?
That is the standard for facial unconstitutionality for statutes that do not infringe on a fundamental right. For statutes that infringe on a fundamental right, the presumption of constitutionality vanishes.
Right, well, I'm not talking about the presumption. I'm
For
talking about the standard for a facial challenge.
when the statute is for a statute to survive strict scrutiny, it cannot be, it can never, it cannot be that in any circumstance that it could be applied constitutionally. It's not that there can't be any circumstance where it can be applied constitutionally, because it has to be narrowly tailored. It has to be that in every single circumstance where the statute could possibly be applied, it would be applied constitutionally.
Accepting a strict scrutiny analysis, you're saying the test is not to apply that scrutiny, and that using that scrutiny, if we were to brainstorm for 20 minutes, we come up with an instance in which the statute passes that test, constitutional muster under strict scrutiny, you're saying this is still facially unconstitutional.
For strict scrutiny, the statute has to be narrowly tailored.
That's not. I'm asking you the difference between an as-applied and a facial challenge.
Yes, Your Honor.
Putting aside the standard, I'll accept your standard.
Yes, Your Honor. For an as-applied challenge would be an argument that in this particular circumstance, the statute was applied on constitutionality. That is not the argument we're making. The argument we're making is that the statute is facially unconstitutional because it does not survive strict scrutiny. It is not narrowly tailored because it can be applied in circumstances where it would be applied unconstitutionally. And under narrow tailoring, that cannot happen for a statute that infringes upon a fundamental right.
And we're supposed to assess that in the first instance.
I am asking this court to assess that in the first instance, even if the court does not accept our argument that facial unconstitutionality challenges are never forfeited. This court does have discretion to consider arguments that are forfeited, especially when they're arguments that are of statewide importance. And this issue.
So let me ask you, Kathy, can we move to the termination grounds? Yes,
Your Honor.
Okay. Explain to me, focusing on the substance abuse ground, whether the test for the ground itself, not best interest, which is the ability to overcome that which led to the initial removal, how that applies here, given the facts of this case as developed in the trial.
I apologize, Your Honor, but I don't understand your question.
So we have two grounds for termination.
Yes.
I want you to focus, if you could, on the substance abuse ground and the hook, right? It has two parts. We have the grounds and we have best interest.
Yes, Your Honor.
Now, for the grounds, they are that a mother has not been able to cure that which caused the problem. Okay? Is that a clear and convincing standard?
As the Supreme Court held in Santaski v. Kramer, the state has to prove all of its allegations that support its grounds for termination by clear and convincing evidence. So it has to prove every element of that ground.
Explain to me why the evidence doesn't support a clear and convincing determination in this case that mother was not able to fix or repair the substance abuse issues that led to the initial removal.
The substance abuse grounds for termination require the state to prove that at the time of termination, at least that's what, for the statute to be constitutional, they have to prove that at the time of termination, that mother was unable to discharge her parental duties, and the way the statute is written is due to a history of drug abuse. And that doesn't make any sense, really, of how a mother could...
I think what we'd like you to do is focus on the facts of this case as established in the court below. We understand your arguments as to the language of the statute and the constitutional grounds. There was sufficient and extensive briefing on those points. But yes, we would like to get a better handle on the record here and what you believe are the facts established below that sort of take this out of clear and convincing grounds. Why is there not clear and convincing evidence of the statutory ground with regard to the substance abuse?
So the first element of the ground is that at the time of termination, the mother was unable to discharge parental duties. The state presented no evidence that at the time of discharge, mother was unable to discharge her parental duties. The state's expert testified, Dr. Thal testified that mother was capable of discharging her parental duties. The DCS's parent aide provided a report, which was submitted into evidence, that laid out 4 different grounds that they were looking for mother to be able to discharge her parental duties. And the parent aide determined that she was able to satisfy all of those grounds. Mother herself testified that she was able to discharge her parental duties. Amy Sasser testified that she had observed mother and found that mother was able to discharge her parental duties at the time of termination. The state didn't present any evidence to conflict that.
The grounds are actually substance abuse and 15 months out of care, right?
Yes.
I understand the point, which is the next sentence, that mother isn't able to fulfill her job responsibilities because of that. But can you focus on that, given that that's the hook, the substance abuse hook? What is it in this case that provides clear and convincing evidence at termination that mother hadn't gotten there and she wasn't going to get there?
Of course, our argument is there wasn't clear and convincing evidence that at the time of termination, mother was abusing drugs. The mother had taken between March of 2017 and the time of termination in December 2018, a period of 22 months. Mother had taken approximately 80 drug tests, and not one of them has she tested positive. She was going to her substance abuse meetings. She had completed treatment. She had gone through counseling. There was absolutely no evidence that the state presented that she was using drugs at the time of termination.
She did have a series of diluted tests, correct? What's your view on that?
I would disagree with the phrasing of a series, because over that 22-month period, there were 6 negative diluted tests, but they were spread out. It wasn't that bam, 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 they all occurred at the same time. They were spread out over that 22-month period. And every single time, it was a negative diluted test. And mother took...
So she had proper negative tests in between the diluted tests?
Yes, Your Honor. They occurred in different months and different years. They were spread out over that 22-month period. And even when the test she took, in order to prove that she was sober and that she deserved to get her kids back, when she tested positive the other times before she decided to turn her life around, every single time DCS had provided a confirmatory test. But when she tested negative diluted, she asked for a confirmatory test, but DCS would not provide one.
Yeah, did she ask for a test, or did she just say she was open to
No,
having?
she specifically requested a test numerous times, and DCS...
So what we saw on the record was a transcript of a hearing in, I think it was in June of 2018, where mother did state to the court that she would be willing to take a blood test. Are you saying, was there a time before that or at a different time where she asked for the blood test?
There was a different time where she asked for a hair follicle test in previous...
What about the blood test?
I'm sorry?
We'll go to the hair follicle test, the blood test.
Yes, Your Honor.
Was there an affirmative request from your client to take a blood test rather than an open?
I do not recall that, whether or not she's affirmatively asked for a blood test. I know she asked for a confirmatory test, and I know that she asked for a hair follicle test. I do not remember if she specifically asked for a blood test.
What's a confirmatory test?
It's when the DCS performs the test again to confirm the original results. And I do know that in the last 6 months before termination, in order to
Did they do
Prove,
that?
I'm sorry?
Did they do that? They confirm it? So 50 clean, 6 diluted,
It is about 80 clean.
80 clean, 6 diluted, and we have confirmatory requests on the 6. The DCS perform confirmatory requests in each of those 6 instances.
They performed confirmatory tests in none of those instances. And mother was so determined to prove that she was sober that in the last 6 months, every test day that she had, she would go and provide a urinalysis, but then also provide a blood test outside of their DCS so that she would have those test results. She also used her own money to pay for a hair follicle test in order to prove that she had not used drugs. And that hair follicle test covers a 3-month period, which covers 2 of those diluted, which definitely calls into question the idea that those diluted showed that she was using drugs, because the hair follicle test showed that she had not been using drugs.
There was testimony about the limitations of the hair follicle test, correct?
Yes, the DCS argued that a hair follicle test only shows continuous use. So their argument that, it's the statute says chronic drug abuse. So their argument was that mother was chronically, sporadically using drugs. And that was the basis for termination. So that's how they explained that the diluted test would still call into question because mother was only sporadically using drugs, but they argued that that sporadic use still qualified as chronic use, which does not really make any sense. So the hair follicle test definitely calls into question that there was evidence of that.
Affirmative drug test that your client was using after removal.
The last time that she tested positive was in February 2017 when the children were removed. After she decided that she was going to turn her life around and become the mother that she wanted to be to her children, after February 2017, she had absolutely no positive drug test, nor was anything else presented that indicated that she was using drugs. All of the evidence showed that she was clean. She was attending sobriety meetings regularly. She had completed her medical assistant credentials and gotten a full-time job with a physician's office. She had gotten an apartment, a clean 2-bedroom apartment that DCS opined was suitable for her and her 2 children. She had gone through counseling, and when she completed all of the counseling that DCS asked of her, she went out into the community and got more counseling. And she went out to the community and took parenting classes. She did everything that was possibly within her power to do to get her kids back. But DCS still petitioned to terminate her rights. It shows in the record twice, and the foster care review board only meets once every 6 months. The 2 foster care review boards before her rights were terminated both noted that how well she was doing and asked the court to reconsider continuing to terminate her rights.
How often do you do these cases frequently?
I do not, Your Honor.
So you don't know how often that happens where the board takes an affirmative position and shares it?
I do not have any statistics on that, but I do know that under the statute, that when the foster care review board meets and makes recommendation, that the court is obligated to comment on those recommendations on the record at the very next hearing, and that did not happen in this case as to either of the foster care review board recommendations. And in those recommendations where they were praising mother, they were also criticizing DCS for not doing what they were supposed to be doing and continuing to put the children in unsuitable homes. During the 2 years that the children were in DCS care, they were switched to homes, 9 different homes. And the DCS just kept putting them in unsuitable homes and then having to move them. And the foster care review board also criticized DCS because they never submitted the permanency plan that they were required to submit under the statute.
So, mother's compliance with what she was supposed to do also goes to the time and care ground, you're saying that because she did all that, she was required to do and more, that there was insufficient evidence on the time and care ground also?
There was, but in Marina P, this court held that in order to satisfy their burden under the time and care grounds, the state has to prove that the parent was notified of the circumstances that would need to be remedied in order to get their children back. Here, there is no evidence that DCS informed mother of what specific circumstances she had to remedy in order to get her kids back. There was testimony, the DCS worker testified that she thought mother needed to fix her attitude, and that was the circumstance that she needed to fix in order to get her kids back. But at the time of termination, the court looked at totally different things. And it looked at whether or not she had housing, and she did, but she had gotten housing with help. And the court said that wasn't good enough. Nobody ever told her that wasn't good enough. Nobody ever told her that if she got an apartment with help from the community, that wouldn't count. And the court also said that she didn't have a job. But there was, all of the evidence that was presented was that she had a job. She presented her paycheck stubs. She testified to having a job. Amy Sizer testified that she had a job. DCS testified that she had a job. There's no evidence that she didn't have a job. So the circumstances, not only did they change them midstream and give her new circumstances that she never knew about, the court's finding that she hadn't remedied those circumstances was not supported by any evidence in the record.
Counsel, your time is almost up. We'll give you a minute for rebuttal.
Thank you, Your Honor.
Counsel?
Good morning, and may it please the court. My name is Autumn Spreitzer, and I'm the Assistant Attorney General representing the Department of Child Safety in this matter. This court cannot disturb the termination of Serah's parental rights without either reweighing the evidence or declaring both the substance abuse and 15-month time and care grounds to be facially unconstitutional.
Should we consider the constitutional argument?
I think this court appears to recognize that that issue is waived, and if I could just elaborate on the question you asked Serah's counsel. Even if this court were to accept that a facial constitutional challenge constituted fundamental prejudicial error, this really isn't a facial challenge. What we have is a hypothetical as-applied challenge, and as this court appears to recognize, that isn't a facial challenge. Serah's argument is that the statute may allow termination in some situations where it may not have been necessary, where some less restrictive or less extreme measure may have done the trick, and that's just not a facial challenge.
So counsel, moving to the grounds, we don't give total discretion to the trial court, right? I mean, we have some role here. Correct?
Correct.
What is that rule? What do we review if
The court reviews just
What would have to happen for us to reverse the trial court finding?
for the court to reverse based on sufficiency of the evidence. You would have to conclude that, given the evidence presented, that no reasonable judge could have reached the same conclusion as the trial court.
Under a clear and convincing standard, right?
Under the clear and convincing standard, correct.
Is it fair to put that another way, that there is not sufficient reasonable evidence to surpass the clear and convincing standard or to meet that standard? So we do have a role in looking at whether or not the evidence provided is reasonable and whether that whatever evidence is reasonable meets clear and convincing standard. Is that
That's
correct?
Correct, Your Honor.
Okay,
And-
so let's talk a little bit about the evidence that we talked about with your colleague here.
Okay.
Approximately 80 clean tests, 6 diluted tests that are sporadic and not in a bunch or not otherwise tied to a positive test, negative hair follicle test, as I understand it, repeated, at least in the months preceding the termination hearing, repeated blood tests that are clean. Where is the positive evidence, any positive or affirmative evidence of drug use within the 22 months prior to termination?
The evidence is because the trial court heard what amounted to expert testimony that those 6 diluted drug tests, and it was a 13-month period, not 22, that doesn't happen by accident. That
When
only
was the last diluted test?
I believe it was either May or June, within 4 months of the trial. There were 2.
Okay, so I'm taking
right after the
the
other.
time period that's relevant, which does go up to the trial.
Mm-hmm.
And what we're looking for is the time period of sobriety, right? Because that was
Right.
one of the concerns.
Mm-hmm.
And the time period of that mother argues she was sober starts in February 2017 and runs through the termination hearing. I understand why DCS would like to narrow that time frame, but let's at least be clear that the time frame should run up to the termination hearing. Isn't that right?
Correct.
So it's more than 13 months then?
Well, the diluted, between the first diluted and the last one, was over.
How about
13
between the
months.
first diluted and the termination hearing?
I
It's more than
don't have the
13
math
months
in my
because
head.
it's that 4
It
months
wasn't
that you just
22.
mentioned. Okay.
It wasn't 22. So, that doesn't
But
happen.
what the expert testimony was, I believe that the DCS has a policy, that was what the case manager said, of inferring from a diluted negative test that there must have been something going on. And you provided expert testimony to say, yes, diluted sample means somebody drank a lot of water. So we're going to infer that they were doing something bad, and that's why they were drinking water. Is that what the expert testimony was?
Correct. And that's not just a DCS policy. That's the drug testing, that whole
But
industry.
typically in the industry, when there's a diluted negative, isn't there a confirmatory test, or isn't there another step before you would take a negative action against somebody for a diluted sample versus a positive sample?
I'm not aware of that, and I don't know that it's in the record,
Okay.
Your Honor. I apologize. It's,
Was there other circumstantial evidence of drug use surrounding the instances of the diluted tests?
I mean, other than the diluted test and the fact that just doesn't happen by accident, not 6 times, not after she's been told how to avoid that. And
Were they 6 in a row or 6 sprinkled throughout?
the first was in November 2017. I'm sorry, May 2017, June 2017, November 7th, 2017, December 7th, 2017. And then the last 2 are in May 30th and June 6th, 2018.
Let me ask you, counsel, you can see that another requirement placed on DCS is it has to make reasonable efforts to keep the family together. You can provide services. Is that accurate?
Yes.
So under this record, 80 clean tests, 6 diluted tests, hair follicle and blood testing show nothing. Was it reasonable for DCS not to provide a confirmatory service on any of those 6 diluted tests and still meet its obligation?
I think that the point of the diluted test is that it's impossible to detect the substance. So why would we retest the same sample? We could always do that, sure.
So
I think the confirmatory test requires a different
A
sample.
new test? Well, because then it's no longer a random test. You cannot allow an addict to dictate when they receive a drug test.
Well,
That,
let's say we're looking for some certainty or a degree of certainty that shows an affirmative. In our last case, we were talking about whether means yes. A yes, rather than a maybe, and 80 no's. Does reasonable services mean a blood test, maybe, or a hair follicle test, or any? When I say confirmation, I use that as it's a nominalization, but a verb. Any efforts to confirm in the face of less than crystal clear or clear and convincing evidence?
I think that, I guess a confirmatory test, I don't know, it wouldn't have been a bad idea, but we have the record that we have, and the trial court looked at all the evidence, not just the diluted drug test, but the,
And I guess that goes to my earlier question is, you said they looked at all the evidence. Other than the diluted tests, what evidence was there of her drug abuse over the relevant time period?
I mean, the drug abuse specifically over the last year of the case, the diluted samples, which don't happen on accident,
Yes.
I think that is all we have. We can make inferences
So-
about some of her
so-
behavior.
And I'm asking this as a fair question. Are you hanging the finding on the diluted tests?
Are we hanging the finding on the drug test?
On the diluted test?
Yes.
Are you meeting
yes,
a
for
clear
the
and
most.
convincing standard based upon those 6 tests alone?
Yes.
Yes, because the juvenile court made that finding.
Okay.
And the juvenile court also looked at the fact that almost 3 years into the case, she was just barely getting started. That came from Dr. Thal's report or his testimony. She had been working less than 3 months. She was just barely getting started, and the court concluded that she just wasn't ready. And I don't think that this court can disturb that conclusion unless it engages in reweighing. So,
What about the 15 months time in care? Or
well, the children had been in and out of care for almost almost 3 years by the time this case ended.
and that's all the state, that's all DCS has to prove is the time period, and that's it.
Well, and that she was still unfit.
Well, don't we have to ask why the child was removed? And that's sort of circular because it's the substance abuse ground?
Right. The children were removed because she was clearly using drugs at the beginning of the case.
We're not here to challenge the pendency.
Okay, I guess I'm not
or the initial
understanding the
ruling.
question.
Judge Chow is just asking about, there were 2 grounds for
Right.
removal identified in the Superior Court.
Mhm.
We've explored substance abuse. I think we're pivoting to the other separate ground, which
Okay.
is 15 months in care. And if I understand that right, the test there is whether mother is able to fix that which led to the initial removal.
Mhm.
And that was substance abuse.
Correct.
So it's
I think
same
that
issue, circular.
So if there is insufficient evidence of drug abuse, and does that necessarily must make the evidence insufficient on the time and care grounds, right? or not?
If there isn't clear and convincing evidence of that she hasn't sufficiently solved her drug problem, then, you know, that would be relevant to both grounds.
Okay.
I'm not sure I understand the question, I'm sorry.
No,
that-
that is my question.
Okay.
Do you want to address best interest? Why is it in the best interest? Moving on, let's say we have the termination. Why is termination the best interest under all cases?
Well, because the children had been in care almost 3 years. They were in an adoptive placement together. They were doing well. If they're if you know the termination permanently protects them from ever again having to deal with mother's ongoing substance abuse. So that's both a detriment if the relationship continues and a benefit from the termination.
Was there an adoption pending?
I don't think there was an adoption pending as of the time of trial, and there's actually an order that, I mean, we couldn't concede, not
Was it an
concede.
adoptable placement?
Yeah,
And
yeah.
you've expressed
There was actually a motion to not start an adoption while the appeal is pending, and there's a court order prohibiting that from being started in the trial court. So, well, I guess if the court has no further questions, I'll waive the rest of my time.
Thank you, counsel. We appreciate your argument, counsel.
Thank you, Your Honor. In this case, the state forced 2 young children to lose their mother. It made them legal orphans. The bond of a mother to their child is one of the most...
Now, counsel, what
I'm just
if
closing up.
we had 50 diluted tests and 10 no's, but no negative, no positive tests? Would that meet a clear and convincing ground that the mother hasn't been able to tackle her substance abuse issues?
I would say whether or not the state would meet its burden of presenting clear and convincing evidence under that would depend on how many clean tests were interspersed with those 50 diluted tests, during what time period those 50 diluted tests occurred, what other evidence there was that the parent was using drugs. I think there's a lot of other evidence that not just diluted results that the state would need to present to meet that standard of presenting clear and convincing evidence. Here, when the state severs the parent-child bond, it has a permanent harmful effect on the child. The state is one of those things where the state absolutely must get it right. It is the infringement of a fundamental right, and the state has a burden, a due process constitutional burden, to present clear and convincing evidence that this parent is unfit.
Thank you, counsel. Your time is up. We
Thank you.
appreciate the arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We stand in recess until this afternoon. Thank you.